In this video, I won't be giving my introduction as a hedge fund, rather, my introduction as a LLB student, as a law student. Many people are writing me on WhatsApp, LinkedIn, Twitter that you are doing LLB. Yes, I'm doing LLB, and I would assure you that if the court would be very kind, which would definitely be the scene, I would be doing LLM also. I'm entering into a practice of law, and I would be integrating my financial intelligence thanks to someone in the sky. Because of her blessings, it is there with the law. I strongly feel that law is a very technical as well as very interesting and very knowledgeable topic, as equivalent as finance. But unfortunately, few people have different opinions, but I hardly bother. To me, law is all about the tactical interpretations in a very fairly accurate and evident manner, in a very pragmatic manner. To me, this is law. Law is all about the judgments by the honorable courts of respective countries on time-to-time basis, the interference we can draw from these judgments, the evidentiary value, the pragmatics, the constitutional validity we can draw from these judgments, and also in what extent we can link these with the practical financial world. I'm trying to do my master's in criminology, in arbitration, and the cross-border disputes. I feel that these three are areas which are very easy for me, at least to me, to learn and comprehend. And I would like to thank you, the respective courts in this regard, and their hard work that on time-to-time basis, they are giving their judgments, their comments, their interferences on the various topics, and I am definitely following them, taking a printout of these and try to learn as maximum as possible. That's always my intent. My special thanks to our current Chief Justice Sir, which is Chandrachud Sir, Chief Justice of India, Supreme Court, for his comment which he made very recently on 5th December 2022. And I'm really thankful to him to making this point. My special thanks also to our ex-Chief Justice Sir, Ramanna Sir. I really literally followed him on the internet, his views, his interpretations on the various topics, and his comments on his inferences, his landmark judgments. And my sincere thanks to Ramanna Sir for giving so much intelligence and knowledge. I really love to meet him at a given point of time in my life. And my special thanks to the current Chief Justice Sir for his excellent piece of work he's up to. Like today, on 10th December 2022, he launched the new version of Supreme Court app. And I would definitely be downloading that, because that would definitely be giving me a beautiful source of knowledge. Thank you to our Chief Justice Sir. On time-to-time basis, he making wonderful statements. And once again, he made a wonderful statement, which I would love to elaborate. Alongside, I would request Chief Justice Sir to kindly consider this in a little different way also. So what I would like to inference to Chief Justice Sir is that Why can't we have this formula which he is proposing? Definitely in an area in which he is proposing, not to mention. Why can't we have this formula in another part also, which would help the judiciary in a very, very big way? First of all, unfortunately, the judiciary system in India is sitting around 4.5 crores open cases, pending cases. And this is the public record. And this is a very huge number and should be reduced as early as possible. And I'm sure that Chief Justice Sir is definitely working in this regard. And one of the finest way he suggested on 5th December 2022 is this. Our Chief Justice Sir said that time has come to impose pre-hearing cost in commercial cases filed in Supreme Court. Okay? He's trying to say that such matters eats into a lot of apex court time and needs to clamp down. Absolutely correct. Perfect statement. So what our Chief Justice is saying that time has come to impose anticipatory cost in commercial matters, which comes to Supreme Court. It is a time for Supreme Court in commercial matters to say that first deposit 5 crores cost, and if frivolous, please note he is stressing on a word frivolous, then the cost would remain with us. The Chief Justice of India orally remarked. The Chief Justice of India observed that many a time, please note many a time, such matters before the top court, apex court, are appealed against ad interim orders of lower court. You do not realize that you come to Supreme Court for such matters and take up our time. You are challenging a division bench order which upheld an ADG order of not granting you ad interim relief. Why should we interfere? He asked. The Chief Justice also recounted how Bombay High Court used to be very strict when such matters when he was a lawyer. I would like to request our Honorable Chief Justice Sir, Chandrachud Sir, that it's definitely a brilliant idea. And I am synced with this idea not only as a law student, but also as a finance person. I also strongly feel that there is a concept called pre-screening cost. Because if you going to be implementing this pre-screening cost, it would definitely, gives a thumbs down to the people who loves fake, frivolous, and those cases who do not have much evidentiary value, constitutional value, and pragmatics in their cases. Like today, I was reading around 41 pages judgment of Supreme Court of India covering FIR. FIR stands First Information Report. An Indian parlance, CRPC, criminal procedures, First Information Report coming under 154. Section 154, you have 154.1, 154.2, and you have respective subsections. Although I'm not yet done, it's a 41 pages judgment. I need to go page by page, line by line, word by word, and it is done by the Constitution Bench of Supreme Court of India. Constitution Bench is considered as a top bench amongst top benches we have in the world. I, on time to time basis, visiting the website of Supreme Court, and they have a section called videos where the arguments are going between lawyers and Constitution Bench, the top lawyers and the Constitution Bench, and I always download these videos on YouTube and listen them and see how these arguments proceed. This, judgment is also by a constitution bench, and believe this judgment is one of the wonderful judgments I ever read, because such a granular judgment, which means the constitution bench, the respective constitution bench went inside the topic, did the thorough research of that topic, and came up with a beautiful facts. And I definitely would be making a comprehensive video of that judgment, because I cannot make a video of 41-pager judgment. It would be more than 5-6 hours, beyond my capacity to do the editing and each and everything. But I would be making a comprehensive video of that judgment, what Supreme Court Constitution Bench is going to, what exactly in short they are giving to the nation, to the FIR, First Information Report Framework, CRPC 154 and respective. I would like to request the Chief Justice, sir, to kindly consider this pre-screening cost in matrimonial and family disputes also. Plus, the concept of penal provisions. Now, I would like to explain my thoughts to Chief Justice, sir, and of course, it's up to him whether he would be accepting or he's not taking that opinion. Now, first of all, I, as we all aware, that the lower courts are the first place where these matrimonial cases are hitting. Basically, the trial courts, in short. From trial courts to session courts to first appellate court, second appellate court to the high courts, in some cases for questioning under CRPC 482. Then if you're not getting, then you are moving to Supreme Court. Of course, as you move, there is, pendency, there is a constraint, there is a litigation cost. It's about, the time factor that comes into the picture. And there are many things which comes into the picture. Our honorable courts on time-to-time basis explain and share sometimes their displeasures also on how these matrimonial cases are, the provisions of these matrimonial cases are rampantly misused. Just like today, I took out a printout of one of the articles on the internet, and this article was about the fake rape cases in India. Fake rape cases in India. Rape cases in India are under 376 IPC, Indian Penal Code 376. And it is considered as one of the most heinous crime we have as far as the law is concerned, and should be. And unfortunately, if the public domain article is speaking that a large quantity of these rape cases are fake, unfortunately, then it's a serious concern. It ends up having litigation cost, time, mental pain, physical pain, mental agony, and beyond my words. Though our judicial framework, our judicial criminal system is having a concept called malicious prosecution under IPC, Indian Penal Code. But unfortunately, before we reach to malicious prosecution, we have litigation cost, we have so many things that comes into the picture. So my request to Chief Justice, sir, in that way, if he is going to be considering that I would, honorable courts including Honorable Supreme Court, respective high courts like Delhi High Court and respective other high courts, on time to time basis shared their versions on the rampant misuse of matrimonial acts. And we should be thank you to the honorable courts for expressing their thoughts in public. We have the respective judgments, like I do have at least 5 to 6 judgments by the Honorable High Court, where they are very clear and the word selection is immaculate. That you cannot take these laws like a drop of an hat. In many judgments, the honorable courts raise a word, the use of these acts, which are originally being designed to prevent, rather to stop the violence on the woman, is now being used in an arm twist manner. And in like today, like the article which I am talking, the Delhi High Court used, I even can't express that we have reached at that level when even the top courts are forced to interfere. We reached at this level. Like, I don't want to say that, but just a couple of days ago, what should I say, that I got a news in public that someone was, I would say, I don't want to use the word blackmail, but someone was trying to implicate a false rape case on a businessman, and that person was seeking money. Just imagine the kind of mental agony, the disrespect in a society, the fall from grace, and so many things you've been through once your name came in public that you did rape. And it's all fake. It's all fake. Just imagine. I request Chief Justice Sir to kindly consider the similar concept. Like I said, the same formula which you're going to be applying. Formula is not different. Of course, the amount would reduce drastically, no doubt. To have a pre-screening cost in matrimonial disputes also, which means Mr. X and Mrs. X. I repeat, Mr. X and Mrs. X are having some matrimonial dispute. And Mrs. X, like generally we see, do 498A, 406, 503, 506, 354A, B, C, D, and unfortunately, even Delhi High Court used a word national tragedy. And they clearly mention these, especially 354, IPC, Indian Penal Code 354, cannot be used as a drop of a hat. So when Mrs. X used to have these, I would say sections, IPC, CRPC, on the Mr. X, and not to mention the Dowry Act, not to mention the Section 24, not to mention the maintenance, not to mention the divorce, and all these things on Mr. X, then let's have a pre-screening cost. Of course, Chief Justice Sir in commercial cases spoke about, though orally, rupees 5 crore. In matrimonial, we can't have 5 crore. Let's start very basic, 1 lakh. Probably take a little low, 80,000. Plus penal provisions, which is once found fake, frivolous, with an intent of doing malicious prosecution, with an intent of faking, intent of damaging someone image, someone reputation, someone career, someone family values, ends up having huge litigation, mental agony, pain, and whatnot. This pre-screening cost would continue to be with the court, number one, plus automatic initiation of the penal provisions, which might be 1 year jail, 2 year jail, 3 year jail, 4 year jail, or it depends that Honorable Constitution Bench, the Chief Justice Sir, needs to decide. I'm not saying that we can have 5 crores in matrimonial cases. I completely agree. And we even can have a provision that I understand completely that not everybody in the matrimonial case can deposit 80,000 even. I completely in sync. In this regards, we can even waive off this 80,000 and we can have severe penal provisions, which means if found fake, frivolous, with an intent, malicious intent, and all these which I already explained, it would be 10-year jail automatic. Automatic. I request Chief Justice Sir to kindly consider this. Sir, I am requesting you, if you're going to be implementing this, the trial court would be free from those cases which are fake and frivolous. And they would focus on the genuine cases, the genuine harassment cases, the genuine rape cases, the genuine things on which the judiciary, the system should focus on. Which would not only give a very thorough focus on each and every case, but also ends up justice as early as possible. As early as possible. I'm not saying that we go with 5 crores. You just go with 80,000. You go even the lesser money. But please, I request the Chief Justice Sir to kindly have the penal provisions also. And sir, you will see a drastic change in the system. Because you yourself and the honorable courts observed the drastic misuse of these acts. And people go to high courts for quashing under 482. Then in some cases they move to Supreme Court also for quashing, which ends up having a lot of mental pain, the physical pain, the family, family pressures, the kind of environment you have in the family, the work stress, the litigation cost, which is definitely not cheap. You know that we have global depression nowadays. The salaries are less, the compensation are less, the jobs are less. Keeping all these, I would request the Honorable Chief Justice Sir, Chandrachud Sir, Honorable Supreme Court of India, Honorable Constitution Bench to kindly consider this proposal. To kindly consider this proposal. This is my humble request to the Supreme Court of India, and this would definitely bringing lot of changes in the system. And if the time permits, if the things go as per plan, I would definitely be filing PIL, public interest litigation, in Honorable Supreme Court, and I would be requesting the Supreme Court to kindly consider these, the family acts, their respective sections, more penal and more dental in provisions, more denting in provisions, so that the people, even in the dreams, are thinking to misuse it, thinking to take that at granted, thinking to use to harass the spouse, thinking to arm twist the matter, even should not think in the dreams. Forget doing it practically on the ground. At the end, I once again thank you to the Honorable Supreme Court, thank you to the Constitution Bench, thank you to our Chief Justice sir for having such wonderful, wonderful steps they are taking in this regard. Thank you once again for launching yet another new version of the app. I would definitely be downloading, which keeps me updated about all the new things which are happening inside the system. Thank you to Supreme Court, and I request Honorable Sir to kindly consider this. I hope so. He would be considering this. Thank you very much. This is Rahul Magan from Treasury Consulting Group, a law student. You knew my number +91 9899 242 978. I repeat +91 9899 242 978. Thank you, guys. Please do understand that law is here to safeguard people. Law is here to help people. Law is here to relieve people from, from the kind of adversities they are facing in the life. But law is not here to misuse people. Law is not here to put fake, frivolous, malicious, and all these cases on someone who even not thought of doing this. Law is not about extorting money from somebody only because the law gave you a right to put a relevant case in a relevant section under CRPC or IPC. Law is not about that. Justice is to help people. Kindly do not misuse that. Probably you are feeling entertained, you are feeling happy when you are misusing the law and justice, but think about a person on whom it is being implemented. He, his family, been through a lot of mental agony, stress, litigation cost, and so much issues. Please think about that. This is not justified. We cannot justify that. This is not a right practice. In legal parlance, we call this as process of abuse of law. And some books and articles even use a word miscarriage also. And honorable courts are forced to share their displeasure about this abuse of law. Please think about that. Kindly do not misuse the law. Use it for a relevant way. Use it for what it is actually designed to help people, to help the society, to help the nation, not for harassing somebody. Please, this is my humble request.